and welcome to today's Industry Insights webinar. My name is Hayden Blucher and I'm the Engagement Lead here at the Building Institute Aotearoa, and I'll be your host for today's session on managing rising costs and construction contracts. Before we get started, I just wanted to quickly run you through a few upcoming opportunities we have at the Institute. You may have seen that we've launched our Building People Awards, which is taking place on the 14th of August up in Auckland at the new convention centre. Entries are now open for these awards and they will close on the 1st of June. So if you are tossing up whether you submit some of your team or yourselves into the awards, please do. Any questions on that, feel free to get in touch with us throughout the entry process. In addition to that, we've got a range of different events such as site visits, networking opportunities, and a few panel events that are now live on our website across the country. Please take a look at our website if you do want to register for any of those or want some more information. Moving on to today's session, we're pleased to have Kathryn Wallace with us today from Legal Vision New Zealand. Kathryn will be talking through the practical contract issues construction businesses should be reviewing now, including rise and fall clauses, provisional sums, insurance, termination rights, and dispute resolution. I guess the aim for today's session is to help you better understand where risk may sit with your current contracts, what options may be available when costs keep rising, and what protections are worth building into new agreements. We will have some time for Q&A, so there is a Q&A function as part of the webinar, so please feel free at any point to drop some questions into that. Depending on the nature of the question, we might answer it at the time, but we will have that dedicated time at the end of the webinar where we will go through some questions and answer what we can. If there are a few curly ones that we can't answer, then we might be able to come back to you, but we'll see how that all goes. So it's my pleasure to introduce Kathryn, and Kathryn, I'll let you now take over and run the webinar. So thank you.
Fantastic. Thank you, Hayden. So welcome everyone to our webinar on managing rising costs in construction contracts. My name is Kathryn Wallace. I am a practice leader in the commercial team at Legal Vision in New Zealand. By watching this webinar, you are eligible to receive a complimentary consultation with us to discuss how we can help your business. So if you are interested in that, you can email us or call the 0800 number. So today we will be discussing managing risks in current contracts, your ability to exit contracts, your insurance, cost-saving opportunities, key new contract provisions to consider, and then, as Hayden has said, we will finish with a question and answer session. So turning now to your current contracts. What you should do first and foremost is look at the terms of your existing contracts. So as we know, with the current war overseas and the increase in fuel costs, it's passing on the increase in costs to everything basically. And it's obviously creating a lot of uncertainty for people, which is not a comfortable position to be in. So the aim today is to give you some guidance and information on ways that you can manage cost increases and hopefully minimize the impact on your business. So the comments today are general in nature. Hopefully they are applicable across a broad range of your contracts and should apply whether you are the contractor or the principal. So to start with, looking at your existing contracts. So some key clauses that it can be helpful to look at are variation clauses. So can you substitute materials for ones that are more cost effective for you? Are there any changes you can make which are a change in scope, which then allow you to pass on those additional costs? Is the same thing happening to you as well? Also looking at price adjustment and rise and fall clauses. So these are probably the key ones here. So if your costs increase, can you pass those on? Do you have any clauses which allow your costs to be tied to indices such as the MBI fuel price index or the Statistics New Zealand CPI index, for example? It's also important to understand where your risks might sit within a contract. So sometimes you'll have liquidated damages clauses. These could apply as a result of your delay in the ability to complete your obligations under the contract, for example, due to supply chain issues. It's really important you understand your exposure here. Equally, are you able to charge liquidated damages if any of your suppliers are late in complying with their obligations or any of your contractors? So something that is talked about quite a bit where there are major global events are force majeure clauses. So given a force majeure clause basically is an event which is completely unforeseen and completely out of someone's control, and it makes it difficult to perform your obligations under the contract. If there's a force majeure clause, it normally steps in to allow you to not fulfill your obligations under a contract without penalty. However, given the current situation is not a new or unforeseen event, these clauses are unlikely to apply, and they do often include exclusions for economic or governmental changes. Another really key important thing that you can do is check whether your contract is fixed price or cost plus. So if your contract is fixed price, this can make it difficult potentially for you to pass on any cost increases. If it's cost plus, you have a broader ability generally to pass on those cost increases. And obviously it goes the same way too. So can your upstream suppliers or principals pass on any cost increases, or subcontractors the same as well? So provisional sums can be really useful. They allow you to vary the price or from what is, I guess, put in the contract where it's a price for a particular item is uncertain. They can help you absorb some cost increases, but I imagine that counterparties are getting quite hot on these at the moment and wanting to limit them. So it's just something to be aware of. Does your contract have a material adverse change clause? So these are unusual. We don't often see them, but normally a material adverse change would be that something happens that's so unexpected that it means that the parties are impacted negatively within the contract. And in that instance, sometimes there is the ability to renegotiate the terms of that contract. Very key also is dispute resolution clauses. So if you have a dispute with your counterparty about costs or passing on costs or supply, what is the dispute resolution process? Normally, it would be parties have a discussion and try and resolve the issue themselves. If they can't, then there may be a more formal resolution process which comes into play, such as mediation or eventually arbitration and, worst case scenario, court. Obviously, dispute resolution can be really time-consuming, expensive and stressful, but it's really important you understand what the process you've agreed to is should a dispute arise. The other thing to look at is default and payment clauses. So if you're late being paid, what can you do under your contract? Can you charge default interest? Are you able to stop providing services? This is ideal. If you're not being paid, you should be able to stop work. If you are late paying, what's your exposure? What can the other party do? And what is the interest rate if there's a default interest rate that applies? It's also important to understand your liability under the contract. So have you got a liability cap? Does the other party have a liability cap? This means that you know in some ways what your total liability under a contract can be, and this can give you certainty regarding your exposure. Once you have had a look at your contract, if there are unfavourable terms in it, do you have the ability to vary or negotiate it? So a general position at contract law is that a contract cannot be amended unless both parties agree. So hopefully your counterparty is open to negotiations or making amendments. So some things that you could look at doing would be to negotiate fuel surcharge clauses. So similar to what we see with freight industry models, this is a percentage increase based on petrol price movements or diesel movements. We're seeing a lot of these be invoked across the industry at the moment. So they can be quite useful. Obviously, they also swing both ways. So if the price in petrol or diesel goes up, then the surcharge applies or goes up. If it goes down, then it wouldn't apply. Another thing that you could look at is a temporary cost sharing arrangement. So is the other party open to sharing these extra costs with you to be more mutually beneficial? And can you also agree a variation to prices? So you may be able to get a temporary price variation agreed. We saw similar to things to this in COVID, and I guess an analogous situation where landlords would agree a decrease in rent during a lockdown period where the tenant couldn't operate from the business. So thinking of the things that you might have done during that period can also be useful here as well. You should be documenting everything. So if you want to increase prices or pass on cost increase, you should have evidence supporting why you need those cost increases. So helping keeping supplier invoices and correspondence, and then of course anything that you document is agreeing with your counterparties regarding prices should be clearly set out and ideally a variation signed. In terms of passing on cost to clients, you should be communicating early with them about potential cost impacts. This just smooths the way for everybody and saves surprises down the track, and hopefully your suppliers are doing, giving you this courtesy as well. You should also be assessing your supply chain. So where are goods coming from that might have major cost increases versus others? Can you identify vulnerabilities or focus on those particular pain points to see if you can make any adjustments to them to help ease the cost increase? So you've had a conversation with you've reviewed your contract, you've had a conversation with your counterparty, nothing is looking good for you, they don't want to agree any changes. Can you get out of your contract? That would be the next thing to look at. So there is a doctrine called frustration in New Zealand, which basically means a contract comes to an end if it becomes impossible to perform. So this is a very high bar, and that's difficult to establish. Again, we only saw it a little bit during COVID, particularly with the first lockdown where, for example, wedding venues couldn't carry out the weddings that they promised that they could. The contract was considered frustrated because neither party could fulfill their obligations under it. Like force majeure, this situation is unlikely to meet that threshold. So then you need to look at other ways that you could potentially get out of the contract. Normally, there are a number of ways you can terminate a contract. So there would be termination for convenience, which means either party generally can decide they want to exit and give notice. If those are in your contract, it's really important you understand the notice periods and then what happens on termination as well. So who has to pay whom until when? Are there any transition provisions or data handover provisions, for example? The other clause that is very commonly in contracts for termination is termination for breach. So this is where one party is in default, i.e. they haven't paid their invoices on time or they're just not complying with other obligations under the agreement. So generally, a termination for breach clause would allow a period to remedy that breach. So often we would see, say, 10 business days, and then if the breach is not remedied within that time, then the other party that's not in breach would terminate. It's really important you understand what might happen there, because sometimes you will see clauses in a contract where if you terminate for breach, you can be penalised, or you have to pay the costs of the other party and they're trying to enforce the contract. Also worth considering insolvency provisions. So often insolvency would be considered a breach under the agreement, but the way that an insolvency clause is drafted can be different, or it can be quite wide or it can be quite narrow. So when I say wide, I mean it could cover anticipated insolvency or potential insolvency versus, say, a more narrow interpretation, which would be actual insolvency. So you've actually had a liquidator appointed or there's actually been a receiver appointed. And then failing that, can you agree to terminate mutually with the other party? So regardless of what a contract says, parties can agree to terminate it. So that's another point worth considering if you need to get out of a contract. So turning now to insurance. Obviously, there are a number of different types of insurance that you may have for your business. Insurance is unlikely to be your magic bullet or solve all of the problems, but it can be useful to assess your insurance position and see if there's anything that you can do to help ease that increased price pain. So contract works insurance, usually this would be in place for all builds, I would expect. Check your policy. If something unforeseen happens, so earthquake, fire, flood, what are the reinstatement costs? Hopefully none of those events do actually happen, but will your insurance policy cover reinstatement costs or only the original contract value? Obviously you'd want it to cover actual reinstatement costs because they will have likely increased since the time that you undertook the project. Professional indemnity insurance does your coverage cover claims which might arise from cost-related disputes or delays in completing your obligations under a contract. If you have business interruption insurance, this can help cover some supply chain disruption costs, and it's really important that you review your policies for exclusions. Quite commonly, we would see that economic conditions or government actions are excluded from reasons for being able to make a claim under a policy. So definitely worth having a review of your policies and talking with your broker if necessary. In terms of making sure you notify your insurer of potential claims or material changes, you should be prompt at letting them know. Obviously, failure to notify promptly can mean that an insurer won't pay out on a claim. So really important you keep them abreast of any issues that arise. And then the other thing is if you've got some big projects coming up down the track, you might want to ensure that you have project-specific insurance which covers any increases in cost or is relatively robust given the current economic situation. So we've talked about some legal things and some insurance things. So what are some practical things that you could do as well besides the legal aspect of things? So some cost-saving opportunities for your business. So if you know that you are going to take on large amounts of the same material for multiple projects, are you able to lock in prices for key materials now? This is obviously a little bit of a risk because the cost of materials could potentially go down and then you've overpaid. But equally, if the price of those materials is only going to go up in the future, then bulk buying now when you know you're going to use them could lock in some of those costs. Of course, it also depends on your financial situation as to whether that's feasible for you. Can you look at alternative suppliers? So can you diversify where you get your materials from to reduce your dependence on single sources? Have a shop around, get competing quotes and pick the ones that are best for you, and don't rely on a sole supplier because if they go under, then obviously that makes things a lot harder for you. If applicable, is prefabrication and modular construction possible? This obviously reduces on-site labour and transport costs because everything is constructed off-site in a factory. Obviously that may not be appropriate for the type of work that you're undertaking, but just something to keep in mind. And then can you optimize your delivery schedule? So what is meant by this is consolidating all of your shipments of materials into one shipment rather than multiple smaller shipments to hopefully reduce your freight costs. Other things to look at would be, can you renegotiate any subcontractor rates? Obviously, there is cost pressure across the industry at the moment, so it may be that your subcontractors are open to accepting revised rates as well. If you know that you've got large projects or machinery or equipment that you use all the time, it might be worth looking at whether you can afford to invest in more fuel efficient machinery, and therefore you're reducing the need to use fossil fuels to power that machinery. Obviously, again, it will depend on your financial situation and if that's feasible. And then again, program acceleration, so looking at your contract. Are you able to move the project forward and finish early so you're reducing your exposure? Are there penalties for doing so? It would be worth having conversations where that's with your other subcontractors and principals to see if that's feasible. So if you are looking at putting in place new contracts or amending your existing ones, you should be amending them or varying them to look at some new clauses to cover yourself. So a lot of these we have already discussed when we talked about varying or reviewing your existing contracts. So you should include comprehensive rise and fall clauses that are tied to specific indexes such as CPI or fuel price indices. It's really important and useful, especially if you want to justify a cost increase, to tie it to specific adjustable costs. So these are materials, fuel, labour, subcontractors, for example. That way you can say that if the cost of your fuel or materials increases, then you're able to pass that cost on. Being realistic about it, it might not be that you're able to pass on every single cost. So setting a threshold can be really useful. So you might be able to adjust the price if your costs increase by, say, more than 5%. The other thing to do is check your administrative burden on this as well, because obviously changing your cost every month is possibly a bit administratively burdensome and will take a lot of time. So it might be worthwhile adding in, say, a quarterly adjustment frequency. There may be a few losses that you wear because of that, because obviously it will be quarterly as opposed to, say, monthly, but it's worth thinking about. And then can you include a fuel surcharge mechanism like we often see with the freight companies, with a clear calculation, so how you are calculating any fuel surcharge and what that is based on. And then also building in contingency allowances. So you've got your project cost. Can you add a, say, 10 to 20% contingency, like an estimate? So the project cost is going to be this, but it may go up to this. That means that it's really clear to both parties from the outset that there may be a change in cost or change in price, and you can then rely on that to make sure your cost increases are passed on. You could look at shorter contract periods, so this would reduce your exposure to long-term price movements. However, of course, this is going to be project specific and will depend on what exactly you're working on and what you're doing. Payment terms, it can be beneficial to have a faster payment cycle to improve cash flow. I know most companies work on a 20th of the month following monthly payment cycle, but is there any scope to adjust that or get agreement from the other party to do that? And then liability caps, which we've also spoken about. So it's really important that you have certainty under the contract as to what your liability would be. So if something happens, do you want to rely on, for example, your insurance cover? Is it capped at the total cost of the project? Is it capped at the number of invoices, the amount of the invoices that you've issued to date, for example? It just gives you some certainty and can help allay the exposure to long-term fuel price increases as well. Having collaborative dispute resolution clauses. So as I mentioned earlier, dispute resolution processes can be very time-consuming, stressful, and expensive. So ones where you are working together to resolve a dispute tend to be better. Adding in provisional sums for your high-risk items. So for example, timber or anything that is dependent on fuel-dependent transport. That just means, as we've said, that you can adjust those prices when you get the actual cost through. The ability to suspend work if you're not paid. So this can help you protect your cash flow. You shouldn't be working if you're not being paid. And then if you are wanting to include some price variation clauses or rise and fall clauses, you shouldn't be putting in a cost cap or a fixed price unless you have built-in contingency within that cap itself. So I understand it's a bit of a stressful time. It is across all the industries. So there's no magic bullet solution to dealing with cost price increases, but more it is a number of levers that you can hopefully pull across your contracts, hopefully your insurance, and then your contracts going forward, as well as some practical steps that you can take to ease that pressure on you. So thank you for listening today. Hopefully it's been useful. You might find our publication useful. So it is a commercial contracts checklist. This can give you a nice, simple checklist to work through when you're looking at a contract or your own contracts that have been put in front of you. You may also be interested in our upcoming event. So employment law changes, there's been quite a few recently as of February this year. So our employment team will be leading this one, and be very helpful, I expect. And then a little bit about Legal Vision. So I will answer any questions that you have shortly. While you submit them, I'll take you a moment to tell you about our membership. So by becoming a Legal Vision member, your business gets unlimited access to our full team of specialist lawyers for all of your business as usual legal needs. So our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more. So as a Legal Vision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We take care of all the business as usual legal work so you can focus on running your business. And if you are in-house counsel, we also offer a dedicated service to manage high volume and business as usual tasks. So if you are interested to learn more about that, feel free to contact our team. Are there any questions?
Yeah, it doesn't look like anything's come through the Q&A function at the moment, but just a reminder to all of the participants, if you do want to put a question in there, if that's proving difficult, you can also use the chat function so we can pick it up as well. I guess just one from myself then. So for the people on the call, if there's potentially, one or two clauses that you would prioritize, first and foremost, is there anything in particular that you might recommend, at least just as a starter?
The price variation clauses, building in the ability to make adjustments when there are material changes to labour or fuel, for example, because that just gives so much room and flexibility if your own costs increase, so you're not absorbing all of them. So that would be a key one. And then I think also the ability to, again, I guess provisional sums as well, but those generally, in my understanding, are used only where there is a bit of uncertainty about what a particular material might cost. And then I think just also the ability to change your payment terms if possible. I know that most people do work on the 20th of the month, and that's very accepted industry-wide, but more cash flow makes it easier for people to continue running their business.
Yeah, absolutely. I've got another question that's come through here. What is the fairest way to manage fuel price volatility in construction contracts without undermining project certainty or delivery outcomes?
That is a really good question. So the fairest way would probably be something along the cost sharing, which I mentioned earlier. If both parties equally share in the cost increases, then I think there would be a feeling of fairness across the board, that you were all sort of sharing the pain equally. And it could be done on, a temporary basis as well. So it wouldn't necessarily need to be for forever, but you might agree on that for, say, a couple of months and then revisit it after that and see where each party's standing. That would be a fair way to do it, I think.
Awesome, thank you. We've got another one that's come through. So we have existing contracts with no fuel price variation. As a small subby, how would you approach that with the head contractor?
You would hope that they are reasonable and are open to a commercial discussion and sympathetic to your plight. That's a really difficult position to be in, obviously, and not ideal, but if they would be willing to agree a variation to the contract to allow a temporary fuel price increase variation to it, that would be ideal. Otherwise, it's, whether you can pull any other levers. So could you then look at your supply chain, your materials, where you're getting those from, and see if you can reduce costs in another way. Alternatively, can you get out of the contract if it's becoming unduly onerous, and what does that mean if you decided you wanted to do that? Bearing in mind, it's that balance between not absorbing all the costs, but then also not losing out on business too.
Another one here. What is the best mechanism in construction contracts to manage rising input costs while maintaining project certainty and viability?
So I think that would be tying an increase to like a specific threshold there. So where you say input costs increase by X%, then there's the ability to adjust the price, because then it gives each party the ability to look at or work within that scope. So no one's going to be surprised by cost increases that just happen randomly. If you have a bit of a process in there, so it hits a particular threshold, if you get to that threshold, what does that mean? You have to give notice. You should show evidence of those costs, and then if that process is followed correctly, then the increase can be passed on. So that would be probably a simplest and fair way of doing it as well. And then it's tight. You always want with contracts, ideally, things to be as certain as possible, because anytime there's vagaries or uncertainty, that can just lead to disputes, which are never fun to deal with.
We've got a couple more questions that have come through the Q&A function. Firstly, thanks for the presentation. I have one question. What risks should we know before terminating the contract?
Yep. So that's where you need to look at what happens if you do terminate. So are there any, I guess, payments that you have to make if you terminate early? What happens to work that you've done but not yet been paid for? Are you going to be paid for that? You should be, but sometimes contracts can be silent on that. And then obviously it's those are the non-legal risks, so the broader reputational risks. Who's the counterparty? Are they going to go and say, don't work with this person, they're terrible, all those sorts of things. So it's looking at it as a whole as opposed to just focusing only on the contract. If you terminate early, have you got other work in the pipeline that you can pick up instead? Do you have any transition obligations to assist with handover of the site, for example? So just really understanding from a holistic perspective what a termination would mean for you.
Brilliant. And another one in here. So regarding contracts that are no longer workable, how does the law define this threshold? I think you've answered this kind of next point, but maybe a bit more clarification. So has a project been unprofitable enough to explore termination rights?
Only if you have the ability to terminate for convenience is basically the simple one on that one. So frustration is a really high bar to meet. That basically provides it has to be impossible to perform the contract. So not just uncomfortable, not just unprofitable, not just difficult, it has to actually be impossible to perform. There is the force majeure clause route as well, but like we said, the current situation is unlikely to meet the threshold for a force majeure because that's aimed at protecting you. So if there's a flood or a catastrophic unexpected event, for example. So in that situation, if you can terminate for convenience, that's your best bet.
Oh, good to have a few questions come through the chat. That's probably most of the questions now, so we can probably wrap up the webinar, unless you've got anything further, Kathryn.
No, just thank you very much for listening to me today. Hopefully it wasn't too full of legalese. I know it's a stressful time, so if we can help at all, please do let us know.
Yeah, awesome. And on behalf of myself and the team at the Building Institute, thank you very much for your time as well. It's been very insightful. Hopefully we'll be able to share those slides with attendees, and obviously then they've got all of the information should they need to contact you further and take up the offer that you mentioned at the start. But everyone on the call, thank you very much for attending. We hope to see you at the next one of these, which is yet to be confirmed, but will come out at some point soon. And have a great rest of your day. Thank you very much. Bye.
Thank you.